embarrassing. And there was resentment of that, but then there was also an attempt to show that they were working on it. So they started making changes even before the settlement was reached. They were in some ways trying to get ahead of the ball to demonstrate that they don't need any more systems of accountability, that they're on it, and that is questionable. So the Department of Justice creates a letter of findings which says that there's a pattern or practice of excessive force against people with mental illness. And again, I believe that if they went back further than just the 18 months, they would have seen that that was not just persons with mental illness, although they certainly are the victim of patterns of excessive force. But I personally was stunned that there was not a finding about communities of color or Spanish-speaking people. In October, the Bureau proposed force policies, followed the next month, or the council passes it, slightly amended. And then there is a settlement agreement. And Dan, will you take it from there?
Okay, so we're going to go through what all these documents mean in just a second. So Bernard described the findings and settlement agreement, and then this last year, the settlement agreement ended up in court, and that's when the coalition was given what's called enhanced amicus status. And normally, there's never been anything called that before. The judge made this up. So enhanced amicus means that enhanced friend of the court, and that the coalition is allowed to speak to the court directly along with the other parties and file paperwork, which, as ordinary citizens, we generally can't do. So it's a very important thing for people from the community to have a seat at the table.
But to have a seat at the table, like I said, you have to be willing to understand what this is. So if this sounds confusing, if your mind is blurring, there's a reason. It is very complex, but we want the community to understand.
Right. So just briefly again, so previously in October of 2012, the Bureau had released some draft changes to the use of force policy and taser policy. And in early 2013, they released what they said were the final versions of those policies. Then in the summer of last year, the coalition signed what's called a collaborative agreement with the DOJ. What the collaborative agreement says, and this is a very important context for tonight's presentation, is that the AMA coalition is not going to object to the agreement being entered into court, but is going to continue to advocate for changes to make it stronger. So, just a point of clarification. And then the Police Association, who had filed an objection to the settlement agreement and became a full party to the lawsuit. So they're beyond an enhanced amicus status. They can actually sit at the table with more power than what the coalition has. They signed an agreement of their own in December that they also are not going to stand in the way of the agreement being entered into the court record, but they reserve the right to object to certain parts of it. At the end of last year, that's when the judge set the fairness hearing, and that's why we're here tonight, to talk about that fairness hearing. Meanwhile, the changes to the systems that are supposed to be being addressed by the agreement are continuing to be changed. And this, as recently as January 8th, the city made some changes to the oversight system, which we'll talk about a little bit later. As Moore mentioned, the deadline for testimony is the 31st, which is this Friday, but the court has agreed to accept testimony up until the day of the hearing, and Joanne will explain some of that when we begin the presentation.